Hi guys, good afternoon, good evening, depending on where you're watching from. Hello, hello. Hi, my name is Alina Shaltsova. I'm an immigration attorney from New York. Tonight we're going to have our live on Facebook, on YouTube, on TikTok, so please join. I'm going to talk to you about recent immigration changes that you need to know about if you would like to have a successful case. I'm going to cover the most important beginning of the most important changes now, and we're going to continue our discussion in my next live this Friday. So join, let me know where you're watching from, say hello. Don't forget to type up your questions because in the end of the presentation, I will be able to help you out a little bit and answer some of you guys' questions for free. Don't forget to send stars and hearts so that I have energy to continue, energy to serve you better, to make my programs more engaging. Regularly, twice a week now, I'm doing this live questions and answers, helping you guys out. And now we're going to start. As I mentioned, today we're going to be discussing the most recent immigration news and changes that are very, very important that are happening in immigration and that you need to know about. Well, first of all, as I mentioned before in my previous programs, what's happening is that USCIS fees, those fees that you must pay to the government if you would like for your case to be approved, they're going up. Very, very important to know that. And if you would like to save some money, actually starting yesterday already, premium processing fees went up. But if you would like to still save some money on certain filing fees, you will need to file your cases prior to April 1st, 2024. After April 1st, the fees are going to go up for some applicants significantly. For some applicants, the fees are going to increase by $1,000, for example. And of course, if you're talking about the B5 case, it's going to be even more. But for most applicants, just family petitioners, those who are filing for adjustment of status, the most common type of application that is being filed with USCIS, you're going to look at increase in fees of about $1,000. I still think it's pretty significant. So if you can, please hurry up. Another important announcement is that H-1B rules are going to change, right? H-1B is that work visa. Many of you who are watching me overseas are asking all the time, what would be the way for me to come and work in the United States? And you need to know that work visas, work opportunities related to immigration status in the United States are extremely limited. But one of the most popular ways one will be able to get that work visa would be H-1B visa, not for everybody, but for people with certain level of skill, education in specialized field of knowledge. This program existed for decades, but recently USCIS decided one more time to change the rules, how it is administered. Why? Because usually there are more applicants for H-1B visa than there are visas available. These visas are limited, hence there is a lottery. The government collects all the applications and then they will choose which one is going to win, which lucky winner is going to get that H-1B visa. But what happened is this. If for one applicant, many companies, more than one company used to file those petitions, then the applicant would have more chances of being picked, right? So USCIS first decided to tweak the rule a little bit, and now a new change is coming. Very important change is the following. Now, the pick is going to be based on the passport number of the applicant, of the beneficiary, that the beneficiary is living with USCIS. And according to the new rules, beneficiary must always use the same passport number, regardless of how many employers are going to be submitting H-1B registrations for one beneficiary. This way, the rule is going to be based on applicant. And according to USCIS, it's going to increase, or it's going to, let me say, make chances of people being picked equal chances for people to be picked. I'm sure that some very smart people will find a way how to game this system as well. But this is what's happening. So the key now, if you are the beneficiary, you would like to receive H-1B visa, you need to use only one passport number. And if for some reason something happens to your passport after you submitted that registration, and before you got your visa, right? And now you have a new passport, be prepared for battle. Try not to lose your passport. Make sure that it's not going to be stolen from you. So your passport will become your most protected entity until you get that H-1B visa. Because USCIS stated in the Department of State that they will have a right to reject your petition for H-1B or even your visa if they find out that now you have a different passport number than the one that was entered during the registration process. Extremely important. And of course, you will have to have that valid passport when you participate in this process of initial registration, and you will have to submit a copy of it to USCIS. All right, so that's how they will know what passport you're going to use. Okay, you will give it to them, as I always answer. Another important change that I'm going to cover today, and I said that the rest I'm going to save for Friday, so please join me on Friday as well. This change relates, guys, to asylum law. For those of you who are in the pending process, if your asylum claim is based on membership in a particular social group, especially that particular social group is your family, you have to know that in the end of December of 2023, Board of Immigration Appeals, one more time, sort of changed the law as to how a claim for asylum based on a membership ground should be considered. One more time. I say one more time because in the recent 5 to 7 years, this one particular category of asylum cases underwent through significant changes in terms of law, and each new administration is trying to improve it or disprove it. But as a practicing attorney, I see how it affects clients. Imagine that if you had a case in November of 2023 and you stated that I'm being persecuted because I'm a member of my family. My family owns a large parcel of land in Mexico, El Salvador, or Honduras. Gangs wanted this land. They killed or threatened to kill some of my family members. Now I believe I'm the target as well because of that. Asylum's granted. But in January of 2024, because of the Board of Immigration Appeals decision, the same identical claim not necessarily will be granted, because to the general analysis that we use as to how we decide whether somebody qualifies for asylum based on the same facts or not, Board of Immigration Appeals decided to add that if one central reason or one reason for persecution is subordinate, superficial, that reason no longer will be considered for asylum cases. For example, the case is based, I'm referring to matter of MSMR. You can Google it, cases based on real facts where one member of the family was actually killed. The courts were in disagreement as to why that member was killed. One court decided that it was related to the fact that gangs wanted to land. Board of Immigration Appeals stated the member of the family was killed for unknown reason. Do you understand how important every single detail is in asylum cases? And then Board of Immigration Appeals stated that the survivors of this horribleness, did not qualify for asylum because the fact that gangs persecuted the family as a family was superficial to the fact that the gangs wanted the land. Boom, that's it. So how do you really establish the fact as to why exactly gangs wanted the land, or did they just hated this family because they wanted the land? That's the art of a lawyer, to convince the judge and the prosecutor that you're going to be appealing the hell out of this case if you don't get an approval, I guess. I cannot describe it in any other way. How some people win on the same facts and some people don't win on the same facts. So asylum is very flexible. I call asylum rules hard rules and soft rules. Those rules that are not subject to interpretation and those rules that are subject to interpretation. Work with an attorney. I hope you have a good one if you have asylum cases. That's the bottom line. Know that the law is currently changing. You have to be prepared when you go for that trial, for that asylum interview. You have to be prepared to address these changes. That's the main point of this particular announcement about the recent change. It's extremely important to stay on top of this wave of changes and be able to rebut whatever arguments the court or the judge would have if you feel that they want to deny your case. And now, if you have some questions, I'll be very happy to answer them. I see my followers from Facebook and YouTube and from TikTok, and I will try to answer all of you guys' questions. Hi, Amar. Hi, the Duke from Washington State. Yay. Hi, Haluka. Hi, Alina. I'm from New Jersey. How are you? By any chance, do you know how long will it take to be approved by the president, the TPS for Ecuador, for example? Thank you. I'll be honest, you're referring to the designation of Ecuador for TPS. I'm not sure it will happen. All right, it's Department of Homeland Security who's announcing it. As you see, they have tons of problems right now at the southern border. I think just today I've heard that both Trump and Biden are trying to make their way to the Mexican border to see what's happening there, because it's not official election campaign, or is it already official election campaign? I do not know. You guys let me know. But obviously, somehow, immigration became one central issue in this upcoming presidential elections. It draws so much attention. So my point is that current administration most likely is going to be very careful when they will be announcing new immigration measures. And will it ever happen? I really do not know. Maybe it happened already. If they came up with an official statement, if you do know, let me know. I just haven't seen it yet. All right. I did check, I think a couple of weeks ago, somebody asked me about that, specifically about Ecuador, and there was no announcement. So if announcement came, let me know. Usually, if the official announcement from the White House arrived, then usually within 30 to 60 days, there will be publication in Federal Register about the new designated TPS, the dates, and everything else. That's how it works. How, Bella? I live in Philly and I have withholding or removal in New York. My I-130 is approved in Philly. I went to court for my individual hearings. The judge sent my case to Philly. Now they give me a new, what did they give you? What new things they gave you? A new date? Maybe they gave you a new date? A new master court. I see. I guess you ran out of characters. They gave you a new master court. All right. So what is your question? Yes, if you guys have withholding or removal, in order to adjust your status, in 99% of the times, you will have to go back to court, immigration court, to do that. In immigration court, once your case is reopened, you may, if it applies to you, or if you want to do that, you may ask the court to terminate your proceedings if you're adjustable and choose USCIS route instead. So that's what's happening with withholding or removal cases. Okay. Now I'm going to take some questions from my TikTok followers. Let's see. All right. Hi, Selena. Hi, Donald. Hi, Karan. I-130 approved, but I am in removal proceedings. My entry was without inspection, but now I got paroled. Very good. What is your question? Okay. Hi, Ali. I got marriage-based green card now to withdraw asylum. Sure. Recently, USCIS started sending letters out that even if you receive the green card, you're not automatically going to have your asylum pending terminated. So if you no longer wish to pursue your asylum, you should send a letter, notarized letter, to USCIS, letting them know that you would like to withdraw it and maybe attach a copy of your green card, okay, showing that you already have status and you have no longer any interest in pursuing your asylum case. Hi, Octavia. How long are F2B visas taking? F2B visas. After category of family preferences, you will need to look at the visibility. I do not recall from the top of my head how long they're going to take, but it's very easy to find out. You need to keep in mind that you have to know your priority date, okay? So if you open the visa bulletin, let's say for February, we're in February right now, final action dates for F2B category are set of October 1st, 2015. Okay, so by calculating, if we just use approximate calculations without any room for changes, I can tell you that it's taking about 9 years. All right, but it doesn't mean that your case is going to take 9 years. Maybe in April of the next year, this time is going to shorten or it's going to expand. All right. Visa bulletin is not moving months to months, just like our calendar year is moving. We have to verify each month as to where we stand in terms of priority dates. How those priority dates are moving up, I do not know. I think in theory, USCIS looks at how many visas they have. But I know for a fact that very often they do not use all the visas available. Still, visa bulletin very rarely advances years at a time. Usually it's months, not years. But now, right now, it's about 9 years. How, Bepi Jr., how long does PD take grant by DHS based on CGIS approved I-360? Well, interestingly enough, usually you would file for PD as soon as you submitted your SIG petition I-360 to USCIS. If that was not done and you waited for the approval, you submit your PD request to the prosecutor and then you have to wait. Depending on the office, I've seen some attorneys stating that they receive emails from OPLA or Office of Principal Legal Advisor, which represents the government and immigration courts, notifications that it's going to take up to 90 days to consider your PD request. And some state it's going to take several months because they're overwhelmed. So I guess it depends on location and your luck, right? Depending on which prosecutor you're going to draw, how fast they're going to work. But typically, usually, you would get your answer within 60 days, typically. Hi, D. I received an RFE for I-751. Do you advise someone to travel with an RFE? Do I advise somebody to travel overseas once you have a request for more evidence pending? I do not know. It depends on the reason for your travel and how long you believe you're going to be missing. If it's a very short time travel, within the time to respond to your request for more evidence, you're going to return, and you exclude all possibilities that you may get stuck overseas, then go for it, okay? It depends, I guess. Depends on how risky you are. Hi, Rafael. Hi, Hamid. Unfortunately, I do not speak French. Hi, Rahit. Hi, the Duke. Marriage petition. How long should an individual take before to filing I-130 after marriage to a U.S. citizen? How long an individual hearing will take before filing I-130 after marriage to a U.S. citizen? Well, individual hearing in court doesn't really depend on your marriage or I-130 pending. However, typically, the judge is going to give you courtesy time for the I-130 to be decided, okay? Once your I-130 is approved, you ask the court, you inform the court about this, and then it depends on the judge when they will note the case for the individual hearing. If you choose to go through adjustment of status in immigration court, that's how it works. I hope I answered your question. If I did not, I apologize. Just please rephrase it, okay? Hi, Saeed Mohammed. Is there any chance of immigration reform in your thoughts? Yes, I do believe that it may happen, but not right now. If it's going to be happening, it's going to be happening closer to elections. You'll see many interesting things before elections. Trust me. Trust me. If you have a defective NTA notice to appear with a final order, can you reopen your case for cancellation or removal? Sure, you can try, but how defective was that? NTA, what was defective about that? What other notices, if anything, you received? Do you have 10 years in the United States of physical presence? Are you a person of good moral character? And most importantly, do you have the qualifying relatives? If answers are yes to these questions, then it's worth it for you to reopen your proceedings. Remember that. Some people better not. Hi, Bima. Hello. Can a U.S. Army help their parents somehow? U.S. Army member help their parents somehow? Sure. If you're a member of the military, there are a couple of benefits that you need to know about. For the parents, if your parents entered the United States without inspection, you may submit for them I-130 petition, of course. You're right. If you are a citizen, and parole in place, allowing them to now get paroled into the United States without leaving the United States. Parole in place typically is granted only to the family members of military personnel. Okay, so that's the biggest benefit. Why does it matter? Because even if you are a US citizen, but your parent does not have legal entry, your parent is not going to be able to receive adjustment of status. It's very important. For that reason, you would want them to get paroled to satisfy this requirement. Also, for military members, you guys have, not for parents now, for your spouses, you have easier ways to qualify for, let's say, removal of the conditions or some other family-related benefits. And for military members, for affidavit of support purposes, you only have to show a little bit less money that you're making than for a person who is not a military member. So there are different leniencies and more actually for military members, but for in relation to parents, the main benefit is ability to request parole in place. And yeah, so if you have some more questions about this, let me know and I'll be happy to answer them. Hi, Kaluka, how are you? How are you? I'm good, thank you. By any chance, do you know how long it will take for the president for the TPS? Okay, for the president to approve TPS for Ecuadorians, we discussed that already. I hope I answered your question. Let me take a couple of questions from my TikTok. Thank you very much, guys, on TikTok. Thank you for sending hearts. I have like the best TikTok followers. My country of citizenship is Palestine, but not listed in USCIS website. Can I put Jordan or Israel? What is the purpose of your application? You may want to put Palestine because what happens is that USCIS announced that special relief is coming for nationals of Palestine. So, you may want to be very specific here. And yeah, I would answer it like that. Do you have a passport? What's in your passport? What does it say in your passport? Where did you receive it from? So I would say show your documents to an attorney, let them know what purpose you are trying to pursue, what is your goal, and then they will be able to advise you. Hi, CEO. Hi, please, I have my pending N400 after interview since May 2023. I need help. You do need help. What happened to you? Why you do not have any answer? Did you pass that interview? Typically, if you pass USCIS naturalization interview, you're going to become a citizen within a couple of months, the most. Okay? So, what happened? Let me know. You can call my office, guys, to set up a consultation, and we're going to go over your immigration history to see where is that hiccup, why it happened. 917-885-2261. Please call between 10 and 6, 10 in the morning and 6 in the evening. Hi, D. Hi, Karan. Hi, Mike. Are most of your clients from Latin America or Eastern Europe? I can't really tell. I do have clients from Central America, right? And clients from Europe and clients from Africa, sometimes even from Australia and Canada. So I wouldn't say that we have a majority of clients from a specific region. We have clients from all over the world. Hi, US, how long is I-601A going to take? Is time going to decrease? I hope the time is going to decrease for consideration of I-601A waivers, but currently it takes more than 2 years to receive a decision on I-601A waiver. When the program first was announced, it would take only 6 to 9 months, guys. 6 to 9 months. And now it takes forever. I feel like almost it defeats the purpose, right? Hi, Unique. Hi there. My individual court was January 24, but it is still pending, not showing new date. All right, so your case was taken off the calendar. If you log in into the EOIR court system and you do not see your case, you don't see the date rather, but you do see your name. Do not freak out unless there is a notation that the case was, the judge ordered removal or something like this. If there is no decision by the judge and no date, things are not so bad. At some point, your date rather will appear in that system. I've noticed currently that more and more judges started taking old cases that were taken off the calendar during the pandemic and noting them for individual hearings. Okay, so it happened in a number of my cases, and I'm sure other lawyers may say the same. So don't worry, you will have the date soon. Thank you very much for the rose, MF. Thank you. Hi, Mux Patel. I-765-C14. Take how long? How long is going to take your application to be granted? It's hard for me to say, but this particular category usually takes the longest. I would say, if I had to estimate, 6 to 7 months at least. Okay. I do have a video about how to receive a work permit in the United States. It is about 3-minute video, and it does give you good ideas about processing times for various categories. It's a very recent video, about a week ago, so you can look at it and you'll see, check it out and you'll see how long approximately it's going to take. All right. Let me see if we have more questions. So now at TikTok. Hi D, I planned to travel March 1st and return March 11th. I have to respond to a refi by May 6th. Listen, without knowing anything about your case, I'd say that you should be able to do that as long as your extension for that I-751 conditional residence status is still valid. All right, make sure that your case is pending, you have extension that is valid, or you have a stamp in your passport showing that you have a permanent residency, even though it's a conditional residency, then you should be good to travel. And check with your attorney just in case. Hi, Julie. How long will it take to apply for such case to 18H kid? How long will it take? Guys, such cases, special immigrant juvenile cases, start in family court. How long family court is going to take, I do not know. Here is an example for you. If you go to Brooklyn Family Court, cases moving so fast like that, especially if the child is aging out, turning 21 soon. You literally sometimes can get decision in days because the court is going to work with you. In Queens, I feel like the Queens family court is the slowest. You will have to appear in Queens several times before the case is resolved. This is just an example of how two different family courts in New York are processing such cases. But in other states, I don't even know. I guess it depends. I know in California, generally speaking, family courts are pretty fast. I'm just judging by stories from my clients. USCIS, on the other hand, is going to take 180 days to decide your I-360 petition. Okay, 180 days. But the child right now is not going to be able to file for adjustment of status for 4.5 years afterwards, just because of the processing delays. Okay, I have a new video on my YouTube channel where I talk about how to get a green card in the United States and how long it takes for every type of green card case. All right. Hi, Yolanda. This is Yolanda. My husband is pending I-45 approval F2A in April 2023. His work permit advance parole were approved. His interview was waived. He also responded to the physical RFE, I guess, and now we're waiting for our priority date to be current. What happens if 2 years go by? Will his medical expire? Can his case be approved without current priority date? Well, I'm going to tell you one thing. His case cannot be approved without the priority date being current. You need to know that. If his case somehow gets approved and his priority date is not current on the date of the approval, what's going to happen is that when he files for his citizenship, and the officer is going to find that out, and sometimes a person will end up in deportation or removal proceedings, even though the person did not do anything wrong. How and why would it happen? Very easily. You probably filed for his adjustment of status. No, maybe not you, but somebody else files for adjustment of status when priority date is current. Then there is a retrogression. It happens very often in employment cases. Retrogression means that the date is no longer current, but goes several years back. Officer, now it's time for the officer to consider someone's case. They pick it up, and they didn't realize that they had to recheck visibility again. They did not know there is a retrogression. They approve the case. You are very happy. You did not know you did anything wrong. After all, you filed everything on time. Now it's time for you to file for citizenship. You go for citizenship. You think it's an easy case. 1, 2, 3. And instead of citizenship, you receive a decision saying that now you're going to be placed in deportation proceedings. That's how it happens. And you didn't do anything wrong. So for cases like yours, I assume that you filed based on current filing dates, right? And there are rules about the medical exam. How long is it going to be valid? When is it going to be expired? I do not know when exactly you filed. I know that there were exceptions to the general rule of validity of the medical exam. However, you need to know this. Typically, a USCIS officer, regardless of those rules, is going to ask you for a new medical exam if more than a year passes from the time you submitted that medical exam. Why? I don't know. That's how it is. Do you want to fight with them, or do you want just to give them new medical exam and forget about it? So you tell me. And that happens all the time. And if other lawyers watch me, please comment to let me know if it happened in your practice. I just tell the clients, go and refresh the medical and forget about it. So you don't have to worry about fights with USCIS. I think that there are better ways to spend your resources, time, and money than worrying about whether the medical expired, didn't expire. If they ask for it, if they need a fresh one, just give it to them. Hi, Karen Eliana Cardenas. If you have a master hearing for your removal case, can you ask the judge in the court to close that and accept your adjustment of status in the same court? I guess the answer is no. Master calendar case, it means that your case just started. Why would you want to close the case and then ask the judge to accept it again? He is not going to, or she's not going to be able to do that if she dismisses the case. Once the case is dismissed in court, you can no longer adjust your status in court, okay? And usually what happens is this. You need some sort of a ground for adjustment. Is it I-130 family petition? Very well. Typically, you have to submit a copy of that petition with a receipt, proof of filing, that it was filed with USCIS to court. The court cannot consider I-130 petition. They can't. Only USCIS can. But once you submitted your I-130 to USCIS, now you have a choice of waiting in court for I-130 to be decided and then asking the judge to adjudicate it, or asking the court to terminate your case, dismiss it in court, and file your adjustment of status with USCIS. There are some exceptions to this rule depending on how you entered the country and if you ever left the country on advance parole, all right? But generally speaking, this would be your typical case scenario. Maybe you referred to asking the court to administratively close your case during the master hearing. So the case is no longer active in court, so that you wait for I-130 approval. And once it is approved, you're going to ask the court to recalendar the matter and file for adjustment of status with the court. You can do that too, okay? So that's how this whole thing is done. And I'm telling you that dealing with immigration cases is not easy. And it's probably, to you, it sounds very confusing. So why don't you play this video back slowly, and then you will see what is the best plan of action for you. And of course, discuss it with your attorney, guys. I see so many times that people don't understand what happens if your case is dismissed and what happens if your case is administratively closed. If you ended up in court because of your asylum case, and now you have only asylum-related work permit, if you dismiss your case in court, that permit is going to die, okay? You'll have to refile for a new work permit based on adjustment of status. And you have to time it right so that you're not left without the work permit. Many people don't understand it. They're not explained that. They say, I agree to PD. But what is PD? It's prosecutorial discretion. They don't understand that it can come in various formats, different forms, with different consequences. Okay, so consult with your lawyer before you're going to ask for this and that in court. It's very, very important. All right, so you will not make a mistake and not get stuck without any papers, not without ability to extend your driver's license for a while, right? Hi, Ramesh. How many months should we stay same state to apply USA citizenship? 3 months, 90 days. 90 days. That's an easy question. All right. Do we have more questions? Let me see. And again, we're going to continue the discussion about changes, because there are more things to discuss. We're going to continue discussion on Friday. I'm going to give you some interesting updates with regard to various areas of United States immigration laws. And don't forget to connect. Hi, Sam. I don't think PD requests are as effective as advertised by ICE claims. I guess I do not know. It depends. It depends what your goal is, what you want to accomplish, you know. If they're effective, sometimes, you know, it's better with a PD request than without. I'm going to tell you that. If administration changes, expect prosecutorial discretion to suffer the most. There was time during the Trump administration when prosecutors would not agree to anything. It was ridiculous because even for family members of military personnel, they would not agree to reopen cases, which was absolutely wrong. As soon as administration changes, the same case was granted like this. Why? It's so unnecessary to do this to people, especially deserving people, right? If you have a family member who is willing to sacrifice their life for this country, why would you not do this little thing and reopen the mother's case? It just doesn't make any sense. This is not a way to build up society. Hi, Joffer. If someone stay more than 10 years and 5-year child, any option for him? If somebody overstayed their visa for more than 10 years or just stayed in the United States and they have a 5-year child, 5 years old child, are there any options? Not automatically. But if there's somebody never had been in immigration court proceedings with the right NTA issued, and if they somehow end up in immigration court proceedings after accumulating 10 years of physical presence, they may, depending on child's situation, request cancellation of removal or green card with a judge. But it's only for those guys who are in immigration court. You cannot currently ask for this relief with USCIS. This, by the way, would be one great change that the government may pass to allow cancellation of removal, something similar for people who qualify, maybe who stayed for 7 years, if to allow it to be filed with USCIS rather than with immigration judges, and to increase quotas available for those visas. Currently, there are only 4,000 visas all around the United States available per year for cancellation of removal applicants. That's just not enough. There are millions of cases in immigration court and USCIS, and you give only 4,000 visas. That's just nowhere any sufficient to resolve the immigration issues. That's just something that really Congress should address, right? Hi, Valeria. About to file for marriage-based green card. Congratulations. How long does it take for CA, conditional card, I guess? I'm not sure what CA stands for. Usually, guys, it takes less than a year, about 11 months, to receive your green card based on marriage, okay? Hi, Innocent. Interesting nickname. I-45 service request sent 15 days ago. No interview or approval yet. What to do? Why do you believe that you should receive an answer from them within 15 days? They're not bound by any specific, timeline. So 15 days is nothing for USCIS. How long your I-45 has been pending altogether? Is it still within the processing times or is it beyond processing times? And honestly, the most effective way to address a case that got stuck is with your congressman. Okay, with your congressman. Well, guys, thank you very much for watching. That would be it for me for tonight, but we will see each other soon. We will see each other soon on Friday. So please don't forget to join. Don't forget to sign up for YouTube, TikTok, if you're following me on TikTok, Facebook. We are going to discuss more interesting changes. I'm going to give you tips here and there, hopefully some useful ones. I don't know. You let me know, and prepare your questions, of course. And I hope to see you soon, very soon. And if everything goes well, we're going to see each other again on Friday night.